Matt Margolis. I'm from Lawtrades. If you don't know what Lawtrades is, we are a legal tech company that provides on-demand and flexible legal support for busy in-house and legal departments. I'm talking about lawyers, paralegals, legal operations professionals, contract managers, compliance specialists, what have you. Thank you so much for coming today. This is Managing Legal Spend. I have an awesome group with me today. I'll allow them to introduce themselves. Andowah, if you don't mind starting.
Sure. Hi, everyone. I'm Andowah Newton. I'm head of litigation at LVMH, Moet, Hennessy, Louis Vuitton. And prior to being in my current position, I worked at law firms for about 8 years as a litigation associate. And I started off my legal career clerking for a judge at the International Criminal Court in The Hague.
That's awesome. Greg?
Hey, I am head of litigation and investigations with Kyndryl. We are a spinoff of IBM. We spun off about a year ago. The company does IT outsourcing services. I started my career as an IP litigator at Skadden. I clerked on the Third Circuit and then gradually kind of broadened to do general commercial litigation, then eventually deals and all kinds of things.
Awesome.
Thanks.
And Zac?
I'm Zac Henderson. I'm head of legal at Levels. We're a health startup. Basically, we create software that allows our members to see how their food and exercise affects their health in real time by letting them compare those food and exercise logs to their real-time health data. Before joining Levels, I was a litigator over at Kirkland in Chicago. And before that, I clerked on the Seventh Circuit for a few years.
I have such imposter syndrome when I talk to you guys. I'll give my background for everyone watching. I started as a litigator. I started actually in insurance defense, and then I transitioned into more of a commercial litigator role. And then somehow I ended up going in-house in private equity and ended up managing all of our insurance as well as our general our litigation portfolio. So I'm very happy to have everyone here. Just to set the stage to kind of explain kind of the purpose of this is plenty of folks that are in-house probably don't have that litigation experience. Luckily, the folks I'm talking to today do. And if you don't, it may be entirely new to manage outside counsel to actually be the one paying the bill and making sure that the ship runs smoothly. So I have these awesome folks with me today to kind of talk through managing outside counsel and more importantly, managing the spend of outside counsel. And I'm not going to poke fun at outside counsel too much because I used to be outside counsel and so did everyone here, but I'm going to poke a little fun. I'm sorry, guys. So I guess let's start at the very beginning, right? How do you pick your vendors? I think that's a big question that everyone always asks, right? And when I say vendors, I don't just mean outside counsel, but I do mean mostly outside counsel. I even mean if you're using third-party administrators of your litigation, if you're using court reporters, if you're using experts, how do you pick, generally speaking, how do you pick your litigation vendors? And whoever wants to start.
I'll jump in. Something in my mind, anyway. I think of some things as more commoditized than others. One thing that I will say is, I don't see ever being commoditizable is your trial counsel, and that is probably the most important strategic decision you make early on. I at least am always thinking of who is going to try the case from the first day, and that should be the person who runs the show and who begins to set the narrative and who gives me the early case assessment and who monitors it throughout. You can debate where that line of value begins to cross over into commodity. Certainly hosting, right? Hosting's just commodity, right? That's a price play, right? The best price I can possibly get. And then everything kind of falls in between, including document review, frankly, including leveraging template interrogatories and things like that, right? Some of that can be commoditized, but where that line is a bit of a judgment call, and it depends on a case-by-case basis. So I start with my trial counsel, then I kind of go from there.
Makes sense.
I can jump in next. So some of these relationships are built in. I've been at my company for 7 years, and when I came, my predecessor was there for 18 years. So,
wow.
Sometimes sometimes these things can be somewhat predetermined, but there were some for which I chose not to continue the relationship for one reason or another that we can get into later. But otherwise, if I'm seeking something new, I often, hit up my law school classmates who are, either currently at firms or in-house someplace and are dealing with similar issues that I'm dealing with. And a couple of, other types of vendors have come from relationships that I established when I was at law firms. So a variety of places.
Sure.
Yeah, and I agree with both of you. I'll latch on to a word that I heard Greg say, which is person, not firm. It's just so important that when we're thinking about hiring litigators in particular, you're not thinking about hiring a firm. You are thinking about hiring an individual because that's really who's working for you ultimately. And we've all, I think, had the experience of even people at the same firm having wildly different styles, approaches to billing, approaches to staffing. And it's really worthwhile to take the time to know the individual you're working with because not all firms are created equal, but neither are the approaches that individuals take.
It's true. I remember being in-house and looking to find litigation counsel, more or less just like a panel litigation counsel. So if there's any sort of commercial work, just goes over. And I was never looking at the firm. I maybe looked at the firm generally speaking, right? Like some firms just have good reputations. So you think that the folks working there have great reputations, but I was looking and I know I did the same thing. I reached out to law school classmates. I'm like, hey, has anyone used this person? Has anyone had this experience? And I did, it was paid back in full. I'm like, here's all the people that I used to use when I was in-house or hey, use me, which honestly isn't terrible because I knew them in law school. I was like, hey, you're pretty good. You didn't take that outline from me. So that I definitely utilize that as well. I did also utilize an RFP process. I don't know if you guys have ever utilized an RFP.
Yeah. I tried a formalized RFP once on a matter that I knew I was going to do an alternate fee arrangement on. And I sort of threw it out there to see who was going to bite. It was somewhat data driven because I had the benefit at that point of several years worth of data gathering on how much each phase of particular kinds of cases cost. And some cases aren't comparable, but this happened to be in the employment space, and that happened to be roughly comparable. I have to tell you, I didn't love it. It became, for me, and maybe it was just that one case, but I lost sight of when I started my answer before, I said I start with my trial counsel. I lost sight of the value of the trial counsel. Everything became about the numbers on the phases. And I was I had already had that baked because I had the data. What I wanted to know was who's going to be the most creative, who's going to be, who's going to staff it with the best folks. So to me, it didn't work. Maybe I needed to tweak and refine, but I never really got back to it. I just sort of said, look, let me use my data and get to the same result, but in a different way.
That's interesting.
Yeah, I think Greg makes a good point. I think that there's some assessment that has to go on within the litigation counsel themselves about whether a case is likely to go to not even to trial, but just further than an answering a complaint and trying to settle. Then you're kind of in the heart of litigation and discovery and everything like that. And you do, all of those things you want to be doing with trial in mind always. But there's some matters for which, for whatever reason, you are going to settle this matter. And I think that decision about who counsel is and who they need to be, changes when that variable changes. So that's something to try to make a reasonable assessment about upfront. And then in terms of RFP, I think the other point that Greg made is important because I think in the cases when it's just about the numbers, when you know what's going to settle, it's easier to do that RFP process as opposed to the cases that you might be in this for a while. And I'll do something informal. Usually I'll gather 2 or 3 people that are known in the space that come from places, and I'll have a conversation with, at our company, we're a conglomerate, so each brand has its own CFO, CEO, and so I'll work with whoever my point person is for that particular matter. Some of them like to be more involved, some of them don't, but I think they all like a choice sometimes. And I kind of advise them on, okay, this one may be cheaper, but they have experience in this, or this one, I really think you should just go for the lowest figure.
Makes sense. We just got a question. It kind of leads to my next question to you guys. I guess I'll combine it. So my question to you guys is, have you ever utilized national counsel? Do you like the national counsel model? And if someone wants to explain what that is, because I think I just said that and realized that someone's listening and thinks I'm crazy, but so I'll leave it at that. If anyone wants to,
I'll jump in again.
Sure.
You know, the nature of the litigation that I handle or my team handles at Kyndryl, and that generally we handled when I was at IBM, it isn't like the construction or mass tort or something like
Sure.
that model where national counsel makes sense. But what we have done, and I think this is more relates to the question that we got,
Sure.
what we have done is, again, I'm hiring my trial counsel, but that doesn't necessarily mean I have to pay the $800 an hour for the senior associate to review documents, right? First of all, I should be disbarred if I'm doing that, but you get my point, right? So
True.
we can decouple all the way down to the level of, you know, partner or partner and key associate, down to the folks who are actually doing the work. That was something I did a lot when I was in private practice, and it's something that I've definitely carried over. There are still a lot of inefficiencies you have to keep an eye on, right? Otherwise, you end up paying to educate 2 different teams or 3 or worse. That's the bigger point for me. Is the key here is always trying to think through what are the misalignments of interests, and then finding ways to mitigate or minimize those. When you have a decoupled model, the inefficiency is the duplication of effort, and so you've just got to, it's more work for you. You got to make sure that both of those teams stay aligned and that you facilitate that alignment without creating inefficiency. So I have, but it still requires a lot of oversight.
Yeah, and when I say national, I've been in that scenario as well, where I think I call it national counsel, but it looks much more like that, where there's trial counsel, if you will, or like national trial counsel, who's advising as to strategy while there's a firm doing maybe the day-to-day. Yeah. And have you ever dealt with something similar to that, or what are your thoughts?
Yeah, you know, and similar to Greg, at first there were no matters that kind of required that national counsel, but then all of a sudden we got a lot of cases relating to asbestos in powder and talc products for cosmetics products. So we had to look at the litigation landscape for those cases very differently, and we did end up going with an insurance panel, trial counsel nationwide, who handles all of our asbestos cases. But we also, in addition, have a supervisory law firm that handles strategy and also communications with our kind of internal clients, most of whom are based in Europe, and that requires some special skill and also knowledge of the company that, you know, a trial counsel who we might bring in just for, you know, a set of recent mass tort matters wouldn't really know and have, you know, because the other firm has been working with our company for decades. So you know, there are multiple reasons why, either to just, you know, get a common strategy together, have the historical background of a company, or because you're getting sued in various jurisdictions and it just makes sense.
Absolutely. That's a good point, by the way, with the national counsel, not just in the sense of like, hey, they're leading strategy, but they actually know the company. So they're like more, it's almost like business minded, like, well, hold on, like, we could do it this direction, but I know the company, this isn't going to fly. This isn't going to work, or this is not the direction that or the messaging. This is not the messaging we want to get across. So that's actually a very good point.
Or one of the things we ran into was, okay, we could challenge that patent on the ground that, for example, software isn't patentable. But then what do we do about the thousands of software patents we own, right? So you do have to be careful about consistency.
That's a good point. Whoops. So that leads me to, I guess, my next question is, so you have counsel, you've selected counsel, but what about maybe certain kinds of litigation? Do you handle it internally? Do you try to handle it internally? Is that at least a push that you try to make? Or do you try to push everything out to external counsel?
Yeah, so I'll chime in here just as from a smaller company perspective and legal department of one. My incentives are a little bit mixed there, because on the one hand, I have very little time, and so I want to push as much out to outside counsel as I can, just to be time protected. On the other hand, because we're still a smaller company, I'm able to have mastery over the entire set of company facts in a way that it may be more difficult to do for much larger legal departments. So I do find myself wanting to be as active as my schedule will allow in anything litigation or litigation adjacent, just because there's so much efficiency that I can sort of offer, and I would say cost savings to be had by being able to kind of hand the facts and relevant documents to outside counsel instead of what may inevitably happen at larger companies, which is there's a lot of hours billed just to learn your company, and I can offer a lot of efficiency and cost savings in sort of short circuiting some of that.
Sure.
I was maybe 2 years into in-house practice, and a case came in that was just laughably small, right? But it didn't fall into any of the easy insurance or tenderable categories.
Sure.
And so I remember going to my boss at the time and saying, "This is ridiculous. I'm just going to take it on myself. I'll show up for the court hearings. I'll write the briefs. I'll do all that stuff." And she sort of had a twinkle in her eye, and she said, "Okay." And I went to the first hearing in federal court and entered my appearance. And the judge said, "No, but who's your outside counsel?" And I said, "No, I'm going to be counsel in this matter." And the judge said, No, really." And I said, "No, really, I'm entering my appearance. I'm barred here. It's like, there's no problem." I got back from the hearing realizing how much just the 26F stuff to do. And I was like, "I can't do this. There's no way." She's like, "I know, that's not what I hired you for. Go get outside counsel." So
I'll do the disclosures myself.
Exactly. So it's tough, right? I mean, both IBM and Kyndryl do a lot of work in-house, but primarily on the transactional side, or corporate side. The litigation stuff is just so voluminous that you'd have to hire a whole law department, like a whole law firm, and now you have other problems that you got to deal with. So I do think that I am training my team to be a proactive team and an involved team and close to the matters, and to add as much of that company perspective as we can. But it's tough in the litigation space to be doing that stuff in-house.
Yeah, I just want to jump in there because I think there's a part of you, especially if you spend a long time at firms beforehand, that kind of wants to actually go in there and go to court and keep
so true
stuff that you used to do. So I certainly felt a lot of that. Like, I just want to go, I want to handle it. But I quickly realize that, we have about 300 matters a year of various sizes. I'm the only litigator at the kind of holding company level. A couple of our brands have counsel, but most of them are not litigators. They've only recently hired one or two. So it's me in terms of litigation. You really do need someone, who could go down to court for a last minute filing or file online or whatever it is. Or, you need a paralegal, you need someone who can do court things on a daily basis, right? And we have shared paralegals in the group, but they're not solely dedicated to litigation matters. So it just became impossible to do that type of work. But I think the value of having an in-house litigator is strategic, actually. So I've had to really distinguish the matters on which it doesn't. I will still review all briefs and all pleadings and all discovery requests and responses. I will do that stuff, but where it makes most sense for me to spend a lot of my time is the case assessment, is the strategy, and to drive that from the very beginning, the choice of counsel, all of that stuff, because I think that's where we actually save the company money, make better decisions, mitigate risk, mitigate ultimate exposure. So it's really a matter of determining how much you as litigation counsel need to be involved on every matter. And but there's some other things that I when it's like vendor disputes or customer issues that have just kind of risen and weren't solved before they got to me, I'll try to do that on my own. I think that there's something unique about having that kind of softer touch. I mean, soft and hard touch, because if you're dealing with the litigation counsel, there's a bit of a hard touch anyway, but softer than going outside. Sure. And if there are things that I know that the client or vendor will be difficult, then sometimes I want to send a message by having outside counsel send them the first letter immediately. So
I have to share this. I'm sorry. I did the same thing that Greg did, and it was a small claims matter. So like small claims, like nothing. And it was such a headache that I remember getting a second related matter, not small claims, but in county courts, just like a little bit more. And I remember calling outside counsel, and they're like, "You sure you want to handle? You don't want to handle this yourself, right?" I'm like, "Absolutely not. Absolutely not. I'm okay. I'll be all right." It was so much work, and it wasn't even federal court. We're talking in county court, small claims. That it was. You're right. Where, I know to your point, like strategic, like be where I can get outside counsel and I can figure out, hey, listen, this case is worth X. We do not need to expend fees in this. This is the strategy that I would prefer. I trust your professional judgment, but I think this is the best move. Let's get here. Let's get to X. So I agree wholeheartedly. And Greg, I'll never do it again. I swear.
I'm tempted. I'm always tempted, right? I'd love to be the person who gets to stand up in court, but I don't mind not being the person who has to stay up until 3 a.m. preparing. But Andowah, I definitely agree with your approach to that the litigators should be a part of the process to intervene on issues before they become problems, and we really do try to do that as well. But it's always amazing to me. I'm like, just once I'd like to be the good cop. Just once. I'm always the bad cop. Like
So
by the time you get to me, by the time we're sending emails from the head of litigation and investigations, the time for good cop is long gone, and now I have to be the bad cop. It's like just
Come on.
I'm a fine. So anyway, funny.
I feel that. So I'm gonna pivot to a question. That's so funny. I'm gonna pivot to a question. I think this is a really good question. I'd love to hear your thoughts on it. I have an answer as well, but so I'll lump this together with a bigger topic. Tech. What tech do you guys use internally, maybe for managing your counsel, managing lawsuits, what have you, or even just managing the bills? And whoever wants to start.
I'm happy to jump in again. Many years ago, I was involved in the project to put in our electronic billing vendor in place, and to kind of merge that with our matter tracking system so that we can get data. It's been many years, so there are probably other products on the market, and I'm always open, and my team is always open and looking. I definitely think that at this point, with the expectations that finance has of us, I don't think that we could be responsive to those expectations without some kind of either or both of an electronic billing system that allows me to run totals very quickly, and or a matter tracking system that allows me to then run more, pivot table type analytics on, okay, well, how much does this kind of matter cost us on a regular basis? When I can throw out statistics like, on average, your average complex commercial services matter is going to cost you, internal client, is going to cost you about $1 million a month once we get kind of underway, and is going to last X number of years. Therefore, P times Q gets you, this is going to be your total. Sure. So that's your cost of that's your sunk cost. When I can do those kinds of things, and those numbers may or may not be real, I just made them up. When I can do those kinds of things, it's much more compelling to have a rationalized conversation with my client that says, wow, okay, so that's going to cost them that much as well, but they've got more options for litigation funding or contingency fees. So let's really talk about how much of a problem we have or don't have. So the short answer is yes, I've used them. I've used at least one. It is essential. I'm not the authority on all of the products out there, but I do know that they're getting better and making those analytics easier to run. That's awesome. Key is data, right? Good data. Crap in, crap out. You got to have good data, and it's got to be clean.
Yeah, Greg, you make an awesome case for data, and I would say this is true in even smaller companies like ours. We stay as a company pretty organized on a platform called Notion. We use bill.com for our billing, but even at our stage where our metrics are minimal, we can't really run data because we don't see enough litigation. It's still critical to be able to surface that to the executive team, to have that visibility. And I would add that in keeping with our conversation about litigation cost, your company's document management system writ large is a huge factor in litigation costs. I mean, how easy it is to locate your documents, whether you can confidently put your name behind saying all documents related to X live here. You don't need to go through A and B and C and D. There's a huge price tag involved in being disorganized across your company. And that's even before getting to the problem of the less organized you are, the more the other side gets to see. So I would say general document management is one of your most important litigation tech stacks, just in a thinking forward capacity.
That's a very fair point, especially with the rise of like aggressive ESI related litigation tactics. Like if you don't have, you're right. If you don't represent like this is literally everything, you're not in for like it's just not a fun time. So that's a very fair point. No, do you want to continue?
Sure. I would just say to those people out there that don't have that much technology, I don't, and but I am keenly aware of how important the numbers are. I have a background as a CPA and auditor for 4 years, so when I was a litigation associate, I paid very close attention to the numbers and how much something should cost over time, and I do apply that knowledge in my current position. But I think the thing about systems is that you also have to have bodies to enter the information into the system. So if you don't have those bodies, you're kind of left with Excel and other more rudimentary tools, but they can get you along just fine. I think if you know what you're looking for, and also, I think regular communication with vendors or outside counsel about where those numbers are landing is important too, in being able to make those assessments of, well, at this point we're 4 months in, discovery has begun or hasn't begun, this is where I expect it to be, where is it? So to Greg's point, it's really about how, having information at hand that you can tell the CFO, this is how much we need to reserve for the end of the quarter. That's really the key.
That's a really good point. Listen, there's especially some of the firms where it's almost like a value add. Like if I'm using an AM100 law firm, they're utilizing the tech as well. They can spit that out to me, especially if I'm paying X amount of dollars, some outrageous amount of money to utilize, like, again, a very awesome counsel. So I couldn't agree more. And I have to say one more time, the imposter syndrome, the fact that you're also a CPA is just like, I can't stress that enough.
I've got to imagine you had to keep that under wraps. Otherwise, you're going to get like all of the security cases, like all of the security cases in the world.
Like, unbelievable. I do not have that background, and I wish I did. It would have been a lot easier.
Yeah, I definitely got the securities cases, the accounting malpractice cases, all of that stuff, but not always.
And I guess I'll say from experience as a litigator, I've utilized, I guess, to name vendors. I'm not going to say if they're good or not, but I've utilized in the past. I've utilized Legal X for legal bills, and this is like your lifetime spend, and this is what it may look like. It may project out. That question, whoever asked that question, I actually will get back to you because I think I have a list that I can send. Anyways, moving forward from that point, let's get to you have counsel. You have counsel. You have everything set up. You're ready to move. Now, counsel is litigating whatever case it is. Let's just talk, I guess, like, how do you manage? Do you want weekly reporting? Do you want monthly reporting? Do you want case evaluations on a weekly, monthly, yearly basis? What does it look like for you guys?
It depends, right?
Nice.
So early in the case, I definitely want a lot more reporting than not, right? I'm going to have to set expectations for my client. I'm going to have to set expectations for myself. I'm going to have to set expectations for my finance people who are going to have to, feel the hurt of the spend. I've got to report to my general counsel who wants to know whether or not we're going to get tagged. So it depends. When we get into kind of steady state, then I think we can settle in, but I'm not just going to let it go away, right? I want to make sure you're not taking 8 depositions when 4 will do. I want to make sure that you're not interviewing my internal witnesses 6 different times because you didn't take notes well enough, right? I'm not going to pay for that. So I would say there are the obvious sort of strategic break points when the complaint comes in or when we're going to send one out, when all of the motions are through and we're beginning to set the strategy for discovery, when summary judgment comes in, a lot around the trial time. But then in between, I would say it can, move out to a broader cadence.
It makes sense to me. Do you want to speak to it, or Zach?
Sure, I can go. It not only depends on where we are in the case, but where we are in the relationship with the outside counsel. How many times have I worked with you in the past? How many times have I worked with you on this type of matter in the past? So do I already have an expectation of where things are? And have we already established a practice of how frequently I'm getting updates? Because if we haven't worked on this type of matter before and you're bringing in other people from your firm that I haven't worked with before, I'm going to ask for those updates a little bit more frequently up front. And then, it also depends on which brand the matter is for, because, going back to my earlier point, different CFOs have different practices. Some like to be more involved. Some like to have more of a heads up. And if I know they're kind of going to be more engaged, I'll ask for an informal, bi-weekly, just tell me your hours. You don't have to calculate everything out, but just a rough estimate versus someone else who's fine with the monthly billing as long as I know where it's headed.
And don't write me a memo when I ask you for an email.
Oh,
right?
my goodness.
If I ask you for three bullets in an email, don't write me a memo.
Yeah.
100% agreed with both of you. And, just to speak to this from maybe a more macro point of view, Greg and Andowah, and to a lesser degree myself, we have litigation experience, so we kind of talk this talk. But if you don't be afraid to be involved. You are the client. It's okay if you're not a litigation expert or even have a lot of litigation knowledge. It's still incredibly useful for you to ask questions, to be involved, to request those emails. I mean, for lots of reasons. I mean, to learn, to contribute, because litigation background or not, you will be able to, but also just from an incentives point of view, my perspective is it's not great for outside counsel to kind of have the impression that you are very hands-off. So just being involved in the first place is already going to head off a large number of potential problems. So if you are like head of legal or general counsel, congratulations, you are at least a little bit of a litigator, whether you want to be or not. And that's probably the mindset that's right to go into these relationships.
That's a really good point. It's true. I spoke to a head of legal fairly recently who was just not versed in IP and was stuck in a Lanham Act case. And coming out of it, they're like, well, now I feel like maybe I'm not an expert, but I definitely know more than what I did going in. And it helps me change policies and procedures. It helps me change effectively the legal department going forward. So I couldn't agree more that if you're not a litigator, get involved, learn. You are, by virtue of being in the legal department, are a litigator, especially if you're a solo. I feel that, Zach. You are welcome. So I agreed wholeheartedly. What about, I guess, guys, what about budgets? Do you ever ask for budgets, at least before the case starts, maybe a rough budget, something formalized?
It's in our billing guidelines, and particularly on big or complicated matters, I will expect to see something that indicates to me that it's going to be done by the lead partner, right? Again, the person who's going to set the strategy for the case. I want to make sure that they're thinking through it holistically. And Doe was dead on point that there are some folks I have more trust that I've already built the trust, and some folks I'm in the process of building that trust, hopefully. But for the most part, on any complicated matter, I do want to see kind of that long view. When are those amounts going to hit? Are you thinking through these things? What went into it? Now, that is not I generally don't apply that as a cap number, right? Where I say you can't exceed that for each of these phases. And sometimes I see the numbers padded because the lawyer thinks, well, this is going to now be, they're going to hold me to this, and that helps bring down the trust. But I usually just, this is about accountability. Are you thinking things through? Are you flagging for me when we're beginning to veer off? And what are we going to do about it, right? Is there a way to economize without losing value so that we can land the plane right around where I told people we were going to land the plane? And if not, that's okay. But there should be a reason, right? Not just because you failed to monitor the associates and they went a little crazy and billed too much in 1 month. So yes, I do look for these things. They're generally directional. It is a strategic thing. And then it's about accountability.
Yeah, and there will always be pushback when you ask law firms what the budget is. I always say, well, it depends on this and that and the other thing. So what I ask more is, what are the possible scenarios under which it could increase, and spell those out and give me two different budgets under case A and then under case B, and extrapolate that out to whatever condition happens after that, as far as is reasonable, because it helps kind of shine a light early on what those points may be for my internal constituents as well. If we choose to go this route or take this strategic decision, or if we get a lot of pushback from the opposing party on a particular issue, then it will cost more money. And I think that's what really needs to be identified head on in terms of decision making, so that people can see that each decision comes with a greater or lesser cost. In other matters, when I've done the same type of matter and over, I will, if I'm working with a new kind of internal brand who hasn't seen this type of matter before, I give them a heads up and I say, hey, this is generally how much legal fees cost on this matter. If you do this, or if you do X, or if you do Y, and then I will let outside counsel know, hey, I told my internal people that this will cost about this much, for those who are shy or waver on giving me an amount. And I say to them, do you think that sounds reasonable? if they're having to
hold them to it, yeah,
on their own.
I like the two budgets. I've never done that. I really like that, where it's like great, not great, and then full explanation of where you go there. And I think that's the thing for us is surprises. I don't want a surprise. Greg, to your point, right? Like if it goes over the budget, awesome. Just tell me why. So, and to your point, where it's like, I'm like, hey guys, it's turning into budget B because of the factors I've already laid out to you at the very onset of this case. So I think that's stellar. So actually I can't use that. Come on, Lawtrades. I wanted to use that because that's a really, I'm like thinking about it now. I'm like, wow, why didn't I never require this in the past? What I used to do is I did have a formalized budget form just for uniformity. Certain cases I couldn't use it because it just was like maybe unique, but certain cases that I did generally know where it was going, or at least in my mind, I had a thought where it was going. I would use that to see also where they're gauging it, outside counsel. And whenever it would go over the formalized budget, all I requested, kind of to everyone's point here, is why are we going over the budget? Give me the reason. So if I can present it to my C-suite, I can say, hey, this is the reason we are going over budget, but the reason is justified. It's not because an associate overbilled in April. It's because XYZ occurred, a motion wasn't granted, and now we have to go in this direction. So I agree wholeheartedly. And so I think this is probably the most important question for everybody. You get the bill. So you get the bill from outside counsel, right? And the bill, what do you look for? What are the red flags for y'all? And what do you require? What do you like to see in the bill?
So I'll jump in again. We do have billing guidelines, right? So our billing guidelines are at least set a baseline for, put people on notice of what we may challenge, right? Mm-hmm. And the more I end up challenging, again, it should be a trust thing. The more I end up challenging, the less I trust you. And just like Zac said, sometimes just the fact that you're paying attention can be a check on some of that. Just the fact that you catch, hey, we don't approve business travel. I had to fly coach to India. So do you. That is enough to say, oh, they caught that. Okay. Right. So we do, as I said, we have billing guidelines. That being said, right, I try my best, because it is a relationship that you're trying to build. Unless it's egregious, I try my best not to say, well, I'm going to take 1/10 off here and 1/10 off there. If the call never happened and you billed me for 5/10 of an hour, I'm going to take, like, that's coming off, right? Mm-hmm. But frankly, if you billed me for 1/10 of an hour when we were trading emails, what's your availability? This is my availability. Okay, we'll set it then. You get a phone call and it'll be like, really, dude? But I may not take it off the bill just because that just causes more problems than it's worth. But on the whole, yeah, I prefer the method of us reviewing it. We're invested in the relationship. You should be invested in the relationship and not overbilling me. So far, I have not used those services, but we do review the bills, and we do review it with an eye towards who's trying to push the envelope on our billing guidelines and who has sort of who gets it.
Yeah.
I have guidelines just relating to what I expect generally in terms of how a matter is handled. And some of that kind of dovetails with billing, so that I shouldn't see names on a bill that haven't already been discussed with me, and that I expect the proportion of hours by the seniority of people will, follow a certain shape and pattern. So those expectations are kind of communicated through my overall guidelines. But yeah, when there's, like Greg said, it's a phone call. Definitely. I try not to send snarky emails back and forth, especially about billing, because people get so sensitive. I say, hey, I got the invoice, let's have a call. And I think people are just more reasonable in reacting to when they hear that you're not happy with a particular bill, when it's by phone. And I found for the most part, I've never had to say, I'm going to take this off. I basically express why, why I didn't think it was appropriate to bill for X, Y, or Z. And the outside counsel usually offers to take that part off because they know that I'm not happy with it. And like Greg said, they know we're building a relationship. So for me, it's not a matter of going through with the red pen and cutting, but just saying, hey, you're making me look bad, right? Because that's part of it too, right? Like, here are certain expectations I have to get things done effectively and efficiently. And I hired you to help me do that. And if I'm not able, if I'm hearing or I have to go to someone and explain why a bill is so high and it shouldn't be, then I look like I'm bad at my job, and that your job is to make me look like I'm good at my job. So let's it's more about couching it in terms of that rather than here's a dollar amount, you spend $5 above that or $10 above that. So I'm mad at you.
Preach. I've been there. I've been there. Zach, you were about to say something.
Well, yeah, I really appreciate all of these comments. I mean, to echo some of those, I certainly am looking to see paralegal hours on the bill, and in significant proportion. Going to a conversation that we had before the call, it's remarkable how much paralegals are capable of doing. And I'm always skeptical when they're underutilized. They really should be the foundation of most law firms' work. I personally tend to have a preference for smaller teams. And so I too don't like to see new names show up. I tend to like smaller teams because, especially at a small company like ours, where we're not dealing with much litigation, the main cost is often the startup learning cost. So every new associate you add means some number of hours that new person is spent kind of getting up to speed. And sometimes for the small matters we deal with, that's half the bill. So I'm keeping an eye open for that. I'll just flag that I love the sort of carrot approach and stick approach that was presented here. So Greg, I probably wouldn't have even considered the precision approach of just saying, I am taking this off the bill. And that's something that I will likely incorporate in the future, because I think I tend more towards the, hey, partner, would you mind taking a look at this? This seems a little high. And that has its place.
A soft approach to it, yeah.
Certainly. And I think there's a place for both, because in my experience, sometimes a soft approach means more hours than I would have asked for comes off, because we're building that relationship. At the same time, I really like the precision approach, because what it demonstrates very clearly is I actually know this stuff. Don't fudge the numbers, because I have my own clock that I'm paying attention to. And that's enormously powerful to make it clear that you are that involved. So I love all of these approaches.
So I'll tie into a question we talked about earlier. One of the benefits of having an electronic billing system is you don't get a timekeeper on my matter unless I approve it, unless I tell my paralegal it's okay, that person can be on that matter. So I don't get new people, right? Until you come to me and you say, I would like to add a new person on the matter. And I say, why? Why do you need a new person on that matter? Aren't you enough? Did you fire the last person? Were they unhappy? Did they go to another firm? Because I should look at that firm. But anyway, so that's one benefit of having an electronic billing system. Another is, and I knew someone who used to call these the low value awards. They would go through, because now you've got all the codes, right? And so you can go through and look at which partner was doing doc review, right?
Yeah.
Just sorted by the codes and the timekeepers. or which paralegal was doing, brief writing or something like that. I totally agree with you. Paralegals and folks at the low end of the billing chain should be doing a lot of the work, but there's some work that's just not appropriate for them to be doing, right? And so, are you on a fixed fee thing, and now you've pushed all that work down to your paralegal? So there was someone who used to do that on a monthly basis, and they would email their lawyer and say, "Congratulations, you've just won the low value award for the month. I just want you to know that I noticed it." Yeah, every month they would send that email out. I never quite got that passive aggressive about it, or I guess just aggressive about it. But yeah, it's an easy way to pick off and let your lawyers know.
I'm leaving Lawtrades for a minute to take that, so I can use that because I want to use that. That is unbelievable.
But I feel like by the time I'm sending that email, like I'm just not hiring you again. Right? You're done. Like we're not talking again.
Well, and isn't that a great point? Because that's what most of us would probably do. And so we can make that law and econ argument of what Greg is doing is helping them for the next client that maybe they won't lose. So
it's true.
Harsh, but maybe useful.
You get one swing at this, man.
That's it. So I'm going to, first off, this is the greatest thing I've ever heard. I'm going to use that. I don't even care if I'm at Lawtrades and head of community. I'm going to use that somehow. Whoever gets that email, I'm so sorry. So, for feeling, I think we all alluded to it or said it overtly, right, that we use guidelines. I just want to say guidelines, at least in my career, have been immensely helpful, both as outside counsel, following guidelines and knowing what the client likes, because those conversations disappear. And then flip, telling outside counsel, Greg, to your point, like you're not flying first class to a deposition. Or mine were also like certain thresholds, right? Like certain vendors, if it was over a certain threshold, just give me a call, tell me, don't just sign them on. So those were immensely helpful. If you're watching this, consider having billing guidelines. If you don't have billing guidelines.
Oh, sorry. That was another point I was going to make for Zac.
Yeah.
Is that electronic system, right? I don't have to call them and say, I just write the travel from $700 down to the price of a coach ticket was $300. I'm paying $300. I can just do it automatically. You don't like, so I don't mean to be a cheerleader for systems and process,
Sure.
but that is one of the benefits. Sometimes I'll make the phone call and say, I noticed this, I'm going to pay for it, but just so you're on notice. And sometimes I will just literally take a $1,000 entry and make it $100 and say, this is the reasonable amount for this work.
I love that.
I love it. And 3 cheers for process. I mean, it's our biggest time saver that we have as lawyers, and it's also our biggest money saver.
Absolutely. I see a question. What is the most common line item you see on a bill that you strike out or find extra fees buried? If I could quickly just ask or answer that in mine, I'd love everyone's thoughts, but doc review. I see it in doc review.
Business class travel every time.
Travel to India.
It's so easy to look for, right? So yeah.
Travel is also one. I see it in doc review more than anything. People would kind of just like put it into doc review. In discovery costs, things get lost in discovery. I think there's also an understanding that discovery can be very expensive. So sometimes I do see discovery costs. Oh, maybe it's inflated, maybe it's not. Obviously, if you have that trust in your counsel, it's likely not inflated. But I have seen in the past in discovery a lot. Also, certain aspects of motion drafting, especially if it's a form motion. And that comes with experience, right? If you see a motion to dismiss on grounds that we all have dealt with in the past, like you didn't attach a contract. All right, come on. It can't be 6 hours. It's not
half hour. Right?
Tops.
Search and replace.
So if anyone else has any thoughts on that, I mean, that's what I used to see. But if not, I guess I have one giant question for everyone here. What happens when litigation spend gets out of control? What is the first thing you do? And how do you bring it back under control?
Go ahead, Andowah.
Okay, I go back to picking up the phone. It might be an email heads up, so we know what we're talking about. And that email heads up might be, hey, there was, I noticed the bill was, this much. And I thought that was really high, or it might say something more specific about the bill. But I always do pick up the phone, even for the little things, because I think it is a relationship, and I want them to understand why, that it's not just it's not me with the red pen, that there are implications for that, right? And if I'm working with a new set of counsel, I say, well, hey, listen, something like this, I would expect to cost this much. Whether if we discuss a certain amount, say, remind them of that amount, or the fact that nothing complicated has occurred in the case yet. Sometimes I've had that conversation, like, yes, I know you might have spent a lot of hours on it, but why did you? Because in this case, nothing special happened. So let me know. Or how many people do you have sitting on calls? My pet peeve. So it's a phone call. It's normally, like I said, them understanding my concerns and them reacting in a certain way. I have had the few occasions when the response wasn't to reduce it, and then I have asked for it to be reduced, and then at that point, it's a conversation of where are we going to end up going forward, and this is where I expect it to land going forward. Do you think you can do that? Because if not, then we need to change direction or think of a different strategy. So it's definitely a pick up the phone.
Sure.
Yeah, I try to think of 3 possible legs to the stool. Was it something the other side did? Was it something outside counsel did? Or frankly, is it something that we did, right? Am I not managing them well enough? Am I making it too hard on them to get to my witnesses, to get to my documents, to understand the direction I want to head, etc.? So I try to both be, think outside, but also be, reflective and say, can we be doing this better?
Yeah, I would agree, and this is certainly something that I would tend toward the phone call with as well. I mean, at the end of the day, the bill is changeable in every case. So if it is something that is genuinely unreasonable, then it's worth it. It's worth to communicate that. This goes back to you are the client, and whether you're a litigator or not, it is okay to push back. It is okay to ask questions. If I ask and I get satisfactory answers, then I get satisfactory answers, and then it kind of is what it is, and maybe we'll work on it a little bit. But if to Greg's point, if the legs of the stool are there, if the bill is truly supported, then you can only think moving forward. But it's okay to push back and make sure that there is a legitimate foundation for what you're being charged.
Agreed. Guys, thank you so much for your time. This has been a fantastic event. I got to talk war stories for me, which is great. I got to talk about my small claims and Greg going to India. So I appreciate all your time. For everyone watching, we have another event on the 20th on Building Community. That's with folks from Bradley Law Firm, Civics, and then Red Cell Partners. And then on the 29th, we're doing one on legal ops with Meta, Nutanix, and Etsy. Also, we have a Lawtrades community, an in-house Lawtrades community. If you have any interest, please reach out to me, reach out to Hannah Longman, and we'd be happy for you to be a part of it. Again, guys, thank you so much for your time, your insight. I really appreciate it, and we'll all talk soon.
This was great.
Thanks.